start recording. Yeah. So folks, the webinar will be recorded, and for your future review, if you want to see this again, you can't get enough of our smiling faces and our wealth of knowledge. We're going to have a link probably within the week to our website under record. I think it's the events or recordings. I forget exactly the link, but it's on there. Or if you have, siblings or other family members who couldn't participate today and you'd like them to have the opportunity to hear the information, they can be referred to that as well. So without further ado, I'm going to go to the slide, which should be up on your screen. There's the cover slide. And then there's just a couple slides with some of our credentials and information. You can certainly read that on your own at some future time. There's me, there's Megan. We got updated photos, so we don't. I don't look like I used to look, and Megan is a little more mature than the teenage-looking picture we used to have up there. But she's
Right.
lovely in either configuration. She's got a great smile, so
Thank you.
we'll go from there. So, with that being said, why are we doing all this? What are your parents or loved ones doing in the context of their estate planning? And just as important, how are you involved? Well, we're going to try to answer those questions. We can't specifically say your exact involvement, but presumably, if you're on here, you're a successor trustee, probably a successor or initial executor under a will, agent under healthcare proxy. And some people have all those roles, some have just selected roles, and you may be fully advised what that involves or what your roles are, or sometimes you don't. But if you are on this, you probably got some information from your loved one about what roles you're going to fulfill. And ultimately, the good news is you are going to be involved in some capacity. And so today we're going to give you some of the background information that will help you, again, understand some of the key provisions. So we're going to start with this fundamental observation that we've seen time and time again over the last, for me, 26 or so years of doing estate planning, Megan just a few less, that most estate plans don't work. And what we mean by that, it doesn't mean necessarily that the document itself, whether it's a will, a trust, a power of attorney, or otherwise, is itself defective. Sometimes it is, but more often than not, it just means that the document and the plan in total doesn't accomplish what the client wanted initially, or even more often, didn't accomplish what could have been accomplished had the client been fully advised about the options that they have. And so you'll have a will or trust, and it says everything goes to my 2 children equally, for example, when I die. The problem is that mom, let's assume it's a widow in this example, had named one of her daughters as beneficiary on most of her bank accounts because the daughter lived down the street, while the other one lives out in Topeka, for example. And what happens in that case, mom dies, the local daughter ends up with all those bank accounts, and the daughter in Topeka gets nothing, or very little relatively. And then the daughter comes crying to the lawyer, oh, why didn't I get my share? Well, the lawyer says, well, it says 50-50, but your mother, we hadn't seen her in 8 years since we did her will. We didn't know what she did in all that period of time. And obviously in that interim, she added your sister to the account. Nothing we can do about it. By operation of law, your sister ends up with those assets. That's the kind of case, and we see it time and time again, where that plan did not work. In our planning, that should never happen. So, whoops, let me get this here. So Megan, why don't you take it from here?
Sure. So when we're doing our planning with our clients, your loved ones, we're trying to hit some key components that we hear over and over again that our clients are really concerned about, what their primary objectives are. And so sort of systematically, we try to approach an estate plan to address all of these things. So 2 of those items are listed here. Clients will tell us that they want the ability to control their property while they're alive and well, right? They don't want restricted access. They don't want things to happen that are not in their control. They worked hard for these assets. They really want to make sure that they are maintaining some level of control, either that they're handling daily management of the asset, or even when they can't, they've at least had the ability to designate those people that they trust to handle and manage those assets when they're unable to do so. So they want to handle it while they're alive and well. And then they want to have a plan in place for themselves and even their loved ones if they became disabled. So disability is actually a big part of estate planning. It's not just after death planning. It's planning for events and circumstances where our client themselves, like I said, can't continue to manage their own property, can't make decisions for themselves. So the legal documentation that's going to be necessary for them to designate someone else to do that is really going to be an important component of their planning. So if we take a look at an example of what some of our estate plans will look like, we're going to see on this slide here a depiction of a trust. And we will, and you will find very likely your loved one's plans include a trust. We will do trust planning very often because trust planning gives us the highest degree of certainty that our clients' wishes and objectives and concerns are all being addressed in a way that's very comprehensive. It lends itself to a more complete plan, and it allows for us to make sure that we don't mistakenly have assets that are not properly connected to the plan in the way that we expect. So what we're trying to do is avoid these unforeseen circumstances, and trusts as an instrument, as a contract, help us to do that in a lot more effective way than other forms of estate planning. So here you're going to see an example of a revocable living trust. That's just one of many kinds of trusts that are out there, but the revocable living trust happens to be one of the most flexible versions of a trust instrument that we can use as part of a plan. And the value of the revocable living trust is that it really does touch on each area of life, disability, and then even after death planning that our clients may be concerned about. So the blue box up top, that's the trust instrument. And within that instrument, it's going to have all of the guidelines, all of the terms for what happens under different circumstances. And our clients are typically starting off as their own trustees, their own managers of their trust. And that allows them to maintain that level of control, and in the revocable trust instance, access to the assets that they've funded to the trust, transferred over to the trust. So our clients are going to start off as their own trustees, but also they're maintaining control because while they had capacity and while they are able to make decisions, they designed their trust agreement, certainly with some guidance from us, but mostly customized by them. They've designed their trust agreement to indicate who's going to be the successor trustee if they can't serve any longer, probably due to incapacity or that they've passed away. So the successor trustee component is important because while the client themselves may not be managing those assets, they've maintained control over the plan, and they were able to designate someone who can manage the trust assets for them. So we have that in the green box in the disability provisions. We not only have those successor trustee provisions who will manage the trust when I can't do it myself anymore, but this green section, it's not actually green in the trust agreement, as you can imagine, but here for the illustration, in the green section, it's also going to describe to the trustee who the priorities are, right? Because if the client's still living, they're just incapacitated, we want to make sure that the trustee is managing the assets for the client's best interest, your loved one's best interest. They're distributing the assets to and for the client's benefit to make sure their quality of life is as much the same as possible. So we have a lot of guidance in there for that. And then who some other beneficiaries of the trust might be, right? So in a married situation, we might say the client and their spouse, both of which would presumably be clients of ours. Often we're providing for children of all ages. So if a parent, a client of ours says, yeah, sometimes I give my kids some money if it's a holiday or to help them out financially, we want the trustee to be able to do those things under those circumstances as well. A trustee can't do anything unless the trust allows for them to do it. So in the provisions of the trust that we customize with the client, we're going to be able to tell that trustee those kinds of instructions or guidance to them for making distributions and managing assets. Now, the disability provisions of the trust in this particular kind of trust, it also has a key function, which is known as the disability panel. And this is a safety feature. The disability panel is a panel of people, trusted people presumably, that the client has selected. And that panel, either by unanimous decision or majority vote, again, the client gets to dictate the terms, can decide or make a determination that the client themselves is no longer able to continue to manage the trust. They should not serve as the trustee any longer, often because of diminished capacity. And so I think this is becoming more relatable today than it even had been in years past. But the scams that we are seeing that our clients are becoming subject to and regular everyday people can fall for are rampant. And what we're trying to make sure of is that our client, as they get older and they maybe start to suffer from some diminished capacity, we want to protect them from themselves and making these missteps, mismanaging property or making distributions to strangers because they believe they won some kind of a lottery or something like that. So in the provisions, and you're going to see them on the screen here, section 502 is primarily where you're going to see the beginnings of the disability panel features in this kind of trust. Here it's going to describe in this example, we want a unanimous decision by the people on the panel. And under 502A1, you'll get to see the panel members that are listed. In this case, we have someone named Martin, Gary, and an attending physician will commonly be on the panel just to get a written doctor's determination that this is truly some kind of diminished capacity or inability to manage finances. So if this panel of people, based on this language here, all unanimously agree that the trust maker should not serve as the trustee any longer, then the trust maker can be removed as their own trustee. Now, the panel doesn't get to choose who those successor trustees are because there's another provision of the trust where the trust maker has already made that determination. So their function on this panel is strictly to remove the trust maker as their own trustee for their own protection. So trust instruments really allow for us to build out these provisions, customize them so that in the document, we have addressed as many of the potential circumstances as possible, and especially during disability, when our client can't continue to make those kinds of decisions, step down on their own, manage assets, things of that nature. So here we see that disability panel feature. In this article, more extensively, that's where we're going to see things like instructions to the successor trustees upon incapacity and the ability to make distributions and things like that.
Right, and this section 501 includes the definition of incapacity, which is pretty common sense. When I'm unable to effectively manage my property or financial affairs because of age, illness, mental disorder, dependence on prescription medication or other substances, or any other cause. A catch-all. But it's really up to those people in section 502A1 who you designate, or your parents in this common context, or your family member, who make that call. And again, it's not some strange judge who you've never met in a guardianship. It's people who are intimately familiar with the client's circumstances and when they are at their peak and when they're not so good anymore. That's why it's an important consideration.
Mm-hmm.
So we'll go back to the PowerPoint, I think, if I can do that. Let me see. Yes, okay, share that. We should be back on this, are we?
Yes.
Good.
Okay, and so continuing with this kind of definition of estate planning, the things that we want to make sure we are addressing because these are the client's concerns. So we see we want the client wants to be able to give, so their assets, right, what they want to who they want at some point, right? They'll get to decide when that happens, when that distribution takes place. And there's different ways that distributions can happen, and they want to make sure that we're giving it in the best way possible based on the client's circumstances or maybe based on the beneficiary's circumstances. And again, trust planning primarily does allow for us to do that. But there's lots of different variations of plans, and almost all of your estate planning is going to address those kinds of distributions. So what we operate under here, what we have is what's called the Legacy Assurance Program. It is a very process-driven way of approaching estate planning, from the initial contact with the client and setting up the plan through the client's lifetime and even upon disability and death. And so what we try to focus on in this program is that each client gets the opportunity to work with a counseling-oriented attorney. While we have computers, and certainly there are tons of forms and templates and things available to us, we are not just plugging names into a standard form and giving everyone the same document, right? There's a lot of counseling and conversation that goes into this. And if your loved ones have told you you should join this program, they probably have told you at least a little bit about the process and how we've spent hours and hours with them at the outset and even as they maintain their plans over many years. So we spend a lot of time asking them questions and advising them and counseling them on what provisions and what options are going to be available to them. We also encourage formal maintenance of the estate plan. And so we do offer a formal updating program. And I would guess that many of the people, your loved ones on this call today, participate in that maintenance program. It's entirely optional, but it is the way that we try to make sure that those plans are always functioning as best they can, based on a lot of different changes that can occur throughout someone's lifetime and that will affect the plan. And then the last one, and this is one that's very important when people come in, and certainly for you guys after your loved one experiences a disability or after death, but we want to assure controlled settlement costs after someone starts to need some kind of a long-term care planning situation or after death. We want to make sure that the plan itself is going to be effective and it's going to work the best way possible so that there are reduced costs on the back end. We try to eliminate or at least minimize surprises and pieces of the plan that aren't fitting nicely together. So that is the emphasis under the Legacy Assurance Program, and it's why we encourage people to participate in the process that we have.
Right. So when you talk about a fundamental planning scenario or structure or process, using the word Megan used and we use all the time, you really have two choices when looking at doing planning. On one end or one side of the spectrum is counseling based planning. The other side of the spectrum is word processing based. And frankly, the vast majority of what passes for estate planning in this country is on this side of the spectrum. It's use of a basic form, often by either the client themselves through an online, software program that they can push buttons, but they don't really understand the implications of the choices. Or frankly, many attorneys use their basic form, and most estate planning is really driven by general practitioners who don't specialize in this area, and so you're not getting custom work. Our practice is very much a counseling based approach, as Megan alluded to, where we sit down and use our knowledge and experience working solely in this practice area to really drill down into the most important questions that the clients need to address and want to address. So looking at some of the ideas here, the concepts, some of the personal planning goals, we want to gain as much clarity of the client's personal and financial situation as we can. And that's where the data intake really starts, with getting a clear picture of the client's finances. We don't just take their word for it. We ask for get the actual statements and copies of deeds and all those kind of things so we can interpret. People frequently misunderstand the way their assets are owned, and not only who owns them, whether it's individual or a choice, trust, or mostly jointly owned assets. Also the types of assets. They think they own an investment account with their husband and wife. It turns out it's an IRA or it's an annuity, or they think they have an annuity and it's not. We really have to make those determinations by seeing the source documentation. So getting an understanding of the clarity, and then talking about what the client's family structure is and who the important players are, is something we need to unpack during our counseling conversations. And then other common goals: avoiding long-term care expenses and nursing home costs. Very big goal for a significant portion of our client base. Helping to protect against a catastrophic illness or the implications of should that occur. What happens to protect their loved ones against creditor attacks, remarriages, and divorces. We'll talk about some of the ways we pass assets in our planning. And of course, tax minimization is a big thing for a lot of people. Many times people think they have a bigger tax issue than they do, not understanding the estate tax exemptions that are significantly larger than they were 15, 20 years ago. But we'll talk about, how we plan around that regardless. Moving ahead. So we use this diagram or this template, this meme almost, as I would call it, as a way to sort of describe the process. All of us who are probably over the age of, I don't know, 25 or 30 have sat behind one of these machines at an optometrist or ophthalmologist's office, and you get the lenses and they flash, they show the letters on a screen that you look through the lenses, and the technician, whoever's conducting your exam, will flip through and they'll say, which one is better, the left eye or the right eye? And if you're like me, you'll always say, please show it again, or 2 or 3 times until you can sort of determine which is clearer. Well, estate planning in our counseling process is sort of along the lines of the eye test machine. We're going to give the client sitting in front of us the many options, and we'll say, here's where we are in the context of your planning. Your trustee selection. Who's the choice of your trustee? Here are your options. You got your individual trustees, your children, other relatives, or your corporate trustee, a corporate fiduciary. Which one looks better to you? Of course, the client will then say, well, give us a little bit of the difference in what will happen if we choose one or the other, and then we'll run through the choices. So this eye exam machine is a good analogy for the kind of planning process that we engage in. Oops. So we talked about working with a counseling-oriented attorney, which are all the previous slides. Now we're going to talk about our maintenance program and why that is such an important component of a successful outcome. So Megan will ask you to take this one.
Sure. So like Rich said, and we've alluded to already several times, we do have this formal maintenance program, and we encourage our clients to participate in it and really take advantage of it, which includes things like annual educational workshops and updates to their plan. And the reason that it's important to do this is because a lot of things change, right? Things change every day, every year, certainly over decades. We're going to see a lot of different changes. So the first change that we're always trying to address with our clients when they come in to see us year after year is any changes in their personal situation. They might have changes in their relationships with people, right? Sometimes there are falling outs, things are a little strained. People make decisions that make the client realize, I had initially chosen them for financial management. Now I'm starting to question if that was such a good idea. So we want to talk about their family situation and make sure that all the people that they've selected in these different positions, yourselves included, that they are still the right people for those positions, for that kind of decision-making and management. There's also changes in the finances. So certainly we hope that our clients are seeing growth financially, right? And that they're always having a little bit more than they had yesterday. But sometimes that's not the case. In either direction, though, we want to make sure that the plan is still sufficient for their financial situation and that their finances, their assets, are properly connected to the estate plan. A very critical component of estate planning and its success is the title of assets. How your assets are titled or your loved one's assets are titled will determine whether that estate plan will be successful, it will function the way we expect it to, or not. And so on an annual basis, not only are we talking to them about their family situation, but we're also asking again about assets. And we are confirming that they're titled correctly, that they have the correct beneficiaries. So we want to make adjustments in both places as needed. And we try to do that as often as annually with our clients. We also generally will see changes in the legal environment. This isn't something that we expect our clients to stay on top of. This is our business. This is what we deal in every day. So even if we weren't sort of scouring the internet and watching for changes in legislation and things like that, we would encounter it in our regular day-to-day work. So this is going to be something that we need to be able to inform our clients about. And even if we have that opportunity to inform them, right, that's generally not enough. We want to be able to adjust their plan to accommodate any legislative changes, tax law changes, things that we're seeing, because it could have a seriously negative effect if their plan stays stagnant. It doesn't change with the changing times. There's outdated provisions in there that could have some negative effects. So we always are keeping our eye on the tax law changes. Certainly in the last few years, we've seen a lot of chatter about changes in the Medicaid laws. And so some of them a little bit more concerning and now, you know, some of them really dormant. And so we'll see where those go and we'll talk about them shortly. And then the ability to protect assets for the client themselves, for their beneficiaries, things of that nature. So we want to stay on top of the laws. We don't expect our clients to do that. But when laws change, we won't have an opportunity to put new provisions in place unless the client comes in to meet us to make updates to their plan.
Right, and sort of putting this a little bit ribbon on that concept, the next several slides will show you the significant tax law legislation. These are all federal laws, you know, starting back with the enactment of the 16th Amendment, which first made the federal income tax technically constitutional. And then there was a fairly large gap between the Internal Revenue Code being even created, you know, 26 years before the IRS or the Internal Revenue Code was actually enacted in our tax system. And then there was the big significant amendment to the IRS code in 1954, and then another big tax law change 20 years later in 1974. But then you see what happens is you start seeing significant acceleration of the modification of tax laws and new tax legislation starting around 1974. And then if we go, is that right? Yeah. Through 1986. And then with 1 year, 3 years, and so on and so forth. I started doing estate planning really in 1999. And you can see since that time, we have, you know, 2.5 or, you know, almost 2 full slides of additional tax legislation. We haven't even actually added anything since 2023, but there have been a few other major tax laws since then. The point of all this is that if you did your planning in 1999 or so, when I first started, and never came back for the, you know, succeeding 26 years, do you think any of these laws may have had impact on the success or failure of your plan if we didn't make modifications? I think the answer is pretty self-explanatory, and therefore we need to have had people come in not just once every 20 years, but hopefully on an annual basis as we do it, to get this planning, you know, updated and compliant with the changes, not only the tax laws, but you know, personal circumstances, Megan said, and other legal changes. Very important concept that we want to make sure you're clear on. The last kind of change that we have to be cognizant of are changes in your attorney's experience. I would like to think I'm a heck of a lot better lawyer than I was in 1999, and I've learned new things. I'm learning new things every day, notwithstanding how long I've been doing this. And part of the fun of the job is learning new things. And then we want to have a mechanism to make sure it gets that newfound knowledge that both Megan and I and our entire team acquire is passed on to our clients. If they're not part of a maintenance program, they're not going to have a mechanism to get that information to them. And therefore, again, that's another major benefit of this program. So the last sort of piece of the legacy assurance program is assuring controlled settlement costs after our client's death. In each of the fee agreements we have with our clients in the maintenance program, there is a fee cap of the cost of settlement. And so if you are tasked with administering your parent or loved one's estate administration, you will have a guaranteed fee cap in working with our firm. Now, any one of you on this Zoom can hire any attorney you wish to do the estate administration. Doesn't have to be with our firm. If your best friend from childhood is an estate lawyer and you want to use them, have at it. You can do so. What the fee agreement binds us is to a commitment to a fee if we are hired to do the work, which frankly, 98% of the time we're going to be hired to do it based on our long-term relationships with your loved one. But again, if you're the one making the choice, you can choose anyone. So Megan, talk about the next piece of our conversation.
Sure. And so we're using, again, a diagram of a trust here, but what we're focusing on is that after death component. And the reason that we want to talk about this is because not only is this where you as the successor trustee or as the helper is likely to come in, but as Rich said, there is a cost to this, and that's because there is work to be done. And no matter what kind of planning a person does, inevitably at some point they come to that realization, wait a minute, you mean even after I put all this together, it just doesn't automatically happen somehow? And unfortunately, the answer is no. I'll tell you that this part of the planning is probably my least favorite part, is the after death administration. It's incredibly sad, but you know, it's not that it's complicated. It's just now I'm dealing with a family member who's probably upset and wishing they had their loved one over this inheritance. I really wish these documents, these trusts that we're putting in place would just do the work for us. If we could make that happen, we would, but we can't. And so what's going to happen is that you're going to have no idea what to do. And part of this program is to give you some ideas, right? And you're going to contact us. And from there, there's going to be some paperwork to be done. There's some maneuvering to be done. How much work there is to be done is going to depend heavily on the kind of planning that your loved one put in place, but I would say heavily on how recently they've updated that plan and how good they were about maintaining the plan. A well-maintained plan is going to have far less work to do on the back end than ones that are outdated for sure. So what we're showing you here is an example of a joint revocable trust. Again, very flexible trust instrument. This one is one trust for, say, a married couple. That's why it's called a joint trust. And we talked about the disability provisions earlier, so we're going to jump to the after death part. And that is when one spouse passes away and the other spouse is still surviving. There's some paperwork, there's some work that gets done at that time. What we're going to find is that we're going to have a division of the assets very likely. And how those assets are divided up is dependent on the client's financial situation and family situation at the time they pass away. And we will have customized all of these provisions before death, obviously, so that what's happening here is consistent with their estate planning objectives, their wishes. What we often find in a joint revocable trust is that a portion of the assets stay with the survivor in a kind of revocable survivor's trust. That's usually about 50% of the assets, but that number can be adjusted again based on the client's circumstances. The other 50% of the assets are considered inherited by the surviving spouse. That's the deceased spouse's portion of the estate. Generally, we're allocating the inherited portion of the estate, again, about 50%, but not necessarily, to either or both a marital and or a family trust. The reason that we find that this structure is very common is because it allows for us to create some level of asset protection for the surviving spouse. It also allows us to mitigate some taxes if we are planning for a client that does have some estate tax or potential estate tax liability. So how we allocate the assets amongst these trusts isn't something that you have to figure out. It's much more of a technical calculation. There's a lot of strategy involved in that. But what's going to happen is we're going to do an asset analysis after the first spouse's death. And at that point, we can start to make recommendations. We'll say we have all these tools available to us. We recommend we take advantage of the marital trust and the survivor's trust. Maybe we don't need a family trust in this situation, and this is why. So we're going to go through that analysis for you and with you so that you're not trying to guess for these things. And we're going to allocate those assets accordingly. So the paperwork that gets done is to formalize these new trusts that are being created. Again, the benefits associated with those trusts are often asset protection, sometimes tax mitigation, things of that nature. And that requires paperwork every step of the way. It not only requires paperwork, but you're probably going to need some assistance with moving the assets around too, retitling these things so that these documents are still functioning through the surviving spouse's lifetime, not just we're dropping the ball and hoping that it works out down the road.
Right. So this slide represents what happens after the death of the first spouse.
Mm-hmm.
The next slide represents what happens after the second spouse dies. If it's a married couple, of course, if it's a single person doing the planning, the prior slide won't exist, and this will then pass from the revocable trust or irrevocable trust, as the case may be, of the single client. And these boxes on the bottom represent ongoing protective trust for the children in this case. Now, it's not always the children who are the beneficiaries. If we have people without children, it could be nieces or nephews or friends or whatever. But let's assume in this case it is a family with children. And here we're just showing child one is getting half of the assets and child two is getting half of the assets. Now, the next slide will show us what happens or the different ways assets can be passed to beneficiaries. And this is really one of the more important slides that we do when we do our workshops in general to our prospective clients, and is really important, I think, for you to understand. There's two fundamental ways to inherit property in this country. One is an outright. Upon my death, I leave 50% to John and 50% to Sally outright. Money, once the executor or fiduciary or trustee is appointed, they pass the money outright. And in outright, there are really three ways that can occur. The lump sum is the most common, but there can be what we call phases and stages. Phases is very common in a boilerplate will type of thing. If my child is under the age of 25, I give them 50% at 25 and 50% at 30. The underlying rationale typically behind that kind of a thing is, okay, if my child at 25 gets the money and blows it, hopefully they learn their lesson, and the other 50% they get at 30, they'll be wiser and won't be so rash with the money. Whether that's true or not, you never know. Stages, it can be, 50% upon graduating college, 20% when they get married, if they do, or some other milestone. But the phases is the more common way to do it. The problem with any of those is that when the money's forced out, there's no protection against that money, against divorcing spouses, third-party creditors, losing assets in a bankruptcy, any of those kind of scenarios. The money is fully at risk, or if the beneficiary needs long-term care someday, no protection of those assets. So we don't like to live on this side of the diagram. We much rather pass our assets or have our clients pass our assets to their loved ones in some form of a trust structure. And it doesn't mean a new trust agreement itself. What happens is we create a subtrust, as shown on that prior slide, where the original trust will divide into new separate ongoing trusts for the beneficiary. And there are really three types, really four that I'll get to that's not on here, the fourth one. The lifetime liberal protective trust is the most common, where the client is not looking to prevent the beneficiary from accessing the money in the trust. Rather, they'll name the beneficiary as a trustee of their own trust, but give it in a trust form so that if the beneficiary does get divorced down the road or have lawsuits and judgments against them, the inherited money is going to be protected in the trust, whatever the beneficiary hasn't taken prior to the date of that crisis event. That's a very common strategy. Now, in the rare cases, relatively rare, where the parent doesn't want the beneficiary to be in control of the trust, have a third party, whether it's through bad financial decisions by that beneficiary over their life, or they have some addiction issues, unfortunately, or they're married someone who the parents don't like, that may be a more conservative trust, which will say distributions for the beneficiary should be for need only. And the beneficiary has to show justification that they need the money. Oh, I only earned this amount of money and I just got hit with a massive dental bill. Or my car broke down, I need to replace it. If the trustee is shown sufficient evidence, then they can provide for them. And then we have what's we call a hybrid trust, which essentially is a conservative trust, but giving the beneficiary a right of withdrawal of a certain dollar amount or percentage of the trust each year. So it's a kind of thing, a very common one is I give my beneficiary the right to withdraw $30,000, no question asked. Anything above that, though, they do have to show need. So it's a way to avoid a scenario where the beneficiary always has to justify to the trustee the reason for the withdrawal, and it gives them a sort of an allowance from the trust. And that's become a more and more popular structure over the years. And the last kind of in trust for is what's called a special needs trust, also known as a supplemental needs trust. Essentially, this is designed for a disabled beneficiary. So if we're working with a family, they already have a disabled child or grandchild, for example, we'll build in a special needs trust for that beneficiary from the get-go. What that ensures that the money can be used for the benefit of that disabled beneficiary, but without disqualifying them from eligibility for needs-based government programs such as SSI or Medicaid. Now, even if we are working with families that don't have a currently disabled beneficiary, we build in a provision that says even a liberal lifetime trust, should the beneficiary somewhere down the line suffer from an event of disability or incapacity, this liberal lifetime trust will be deemed converted automatically upon triggering event of disability into a special needs trust so that those assets can then be protected without having the beneficiary forfeit the right to government assistance programs. If the money was already passed out to the child on the left side of the screen, this is never possible. You can't put the genie back in the bottle. And ultimately, the question of who the trustee is going to be for these trusts is really going to be driven. If it's a liberal lifetime trust, more often than not, the beneficiary will serve as their trustee. If it's a conservative or S&T, then you're going to have a third party, whether it's a family member, a corporate trustee like a bank trust department, or some combination of these things. These all come down to counseling decisions, and our job is to counsel the family and the client about their choices and what fits their circumstance. So that is really an important slide for you to understand and how these things will work going forward. So Megan, talk about our IRT structure.
Yeah, so another kind of trust that you as helpers may encounter that your loved ones may have put together is a kind of irrevocable trust that is very common amongst our estate planning clients. And the purpose behind using this particular kind of trust is to give some asset protection for our clients' assets in the event that they need long-term care. Now, long-term care, the reason we're planning for it is that it is very expensive. So if your loved one was paying for it privately, the concern would be that they would quickly start depleting their assets and they wouldn't have anything to leave to their loved ones, whether it be a surviving spouse or to children, because if they needed care for a prolonged period, the expense of that care would diminish the estate. So with an irrevocable trust, that is an estate planning tool. So just part of the regular estate planning objectives, but it's a tool that adds the additional benefit of asset protection, particularly if they end up needing long-term care. The tricky part with protecting assets for long-term care is that when we are trying to avoid using our own private assets to pay for that care, what we're actually saying is that we are seeking Medicaid, a government benefit, to pay for those long-term care costs. aid service to your home, assisted living, nursing home care, Medicaid will pay for each of those things, but the client has to be able to demonstrate that they meet certain financial criteria. Essentially, they're impoverished. They meet that financial criteria, and they also have a medical need. So this trust structure, the irrevocable trust in particular, makes it appear as though the client meets that criteria. They're technically impoverished because we've successfully moved assets out of their name, but it still has a lot of benefit associated with it because we're not just gifting those assets to other people. It's a controlled setting. That trust creates that level of control. One of the things that we're dancing around regarding that Medicaid benefit is what's known as the look-back period. Now, for community Medicaid right now, there is no look-back period that is being applied. And that look-back period is how far in advance of needing Medicaid is Department of Social Services going to look to see if the client has given away any assets. That could be gifts to kids, to friends, or even to this irrevocable trust structure. However, back in 2020, a look-back period was introduced for community level care. That's care in your home, that's assisted living. That was going to be a 2.5-year look-back period. So if our clients created this trust and within 2.5 years of creating the trust, they need some care in their home or assisted living, that trust is not yet protected. It's not going to be effective to protect those assets. However, that 2.5-year look-back period has not been enforced at this point, primarily because it happened during COVID, and then there was a lot of incentive to push it off, and now logistically they can't quite figure it out. So we're keeping an eye on that. That's one of those legislative changes, right, that we're trying to monitor to make sure our clients are aware of it if it happens. For now, what is in place and what is effective is a 5-year look back for nursing home level care. The concept is the same though. If the trust was created within 5 years of the client needing a nursing home and expecting Medicaid to pay for that nursing home care, the trust is not yet protective. So the key to this kind of planning is doing it well in advance of the client actually needing the care, which is why it's considered proactive planning. It's looking a little further down the road in the future to say at some point I may need care while I'm healthy, long before I need that care. Maybe I should take some steps to protect assets now. So when the time comes, this is already safe and secure. The irrevocable trust does that. We want to get it in place nice and early so that we can make it past those potential look back periods. 2.5 years if it becomes effective, and then certainly the 5 years, which is in place and effective currently. We call it the Medicaid Asset Protection Trust, which is a kind of irrevocable trust. And it does come with some restrictions, which is the trade-off to receiving that protection. The first is that we have to identify it as an irrevocable trust, although in New York and most other states, your parents, your loved ones could terminate the irrevocable trust if for some reason circumstances changed and this was not a good strategy for them any longer. The other is that the trust language itself has to say that once they create this trust, the trust maker no longer has direct access to the principal of the assets within that trust. And by not being able to access the principal, it means that your loved ones can't dip into that trust to pay for their care needs if that ever occurred in the future. So Department of Social Services can't make them do that. So there's restricted access, or there's no access. There's a restriction on the ability to access principal. However, most of our irrevocable trusts are structured to pay income to the trust maker, to your loved one. So if they fund the trust, move an asset into the trust, that is, say, an investment account, and that investment account is generating some income, some interest or dividends, they can still receive that income, that interest, those dividends. They just can't touch the principal amount. We do create a little bit of a loophole in there in case they want to be able to distribute principal out to other people, just not to themselves directly. We describe this as almost always a better choice than outright gifting, though, because the trust, as I said before, allows the trust maker, your loved one, to maintain control over the assets, how they're managed, how they're invested, those kinds of things, right? It keeps them protected from exposures or liabilities from outside sources. So for instance, if someone gave their house to their child, but then their child experienced some kind of a lawsuit, a creditor issue, or a divorce, that house could be subject to those liabilities of the child now that it's in the child's name. The trust prevents that from happening. We're not exposing it to additional liability. The trust also ensures that when that asset eventually passes to the next layer of beneficiaries, often the children, that those beneficiaries will get an adjusted cost basis for that property, that asset, giving them a better capital gains situation, a better capital gains result than had an outright gift been done. So here you're going to see the diagram of the irrevocable trust. This trust can be a single trust or one trust for a married couple, so a joint trust. You're going to see the language of the trust here in the diagram says we cannot give the trust makers direct access to principal, so that will be off limits to them. Because of that, it is a very strategic conversation about what goes into the trust versus what stays out of the trust. We want to leave things outside of the trust so that your loved ones have access to the funds, have the ability to spend it, and keep their quality of life as much the same as possible. We're only going to move things into the trust that we could anticipate they're probably not going to need to access the principal. So a little in and a little out, and that way we're finding a nice balance. Income, like we said, can be payable to the trust maker over the course of their lifetime, so that's permitted. The day the assets move from the trust maker's name into the trust, that's what starts that 5-year period that we're watching out for nursing home Medicaid purposes. So the day the asset enters the trust is the day that matters, not necessarily the date of trust creation, although in our process, we often will have everything funded on the date of trust creation or as much as possible. Our clients do typically start off as their own trustees, even of their irrevocable trust. And then their trust itself is going to have those successor provisions. The client will have customized who should take over if they lost capacity, lost the ability to manage finances, and eventually pass away. The trust, like I indicated before, will have a little bit of a loophole. It will have a provision that does authorize the trustees to distribute principal out to other designated beneficiaries. Those beneficiaries are selected again by the client, so that is a custom provision. It usually includes kids and grandkids, but it can include anyone that they want to put on the list, just not themselves, not their spouse, if it's a single trust married situation. So this can be because the client wants the ability to give money to their kids or grandkids because, the holidays might be coming up. They want to be able to make normal gifts, big life events. It could also be used to transfer some of the trust assets out to a child with the expectation that the child will turn around and give those assets back to the parent. So it's a two-step process, but it is a way that we can siphon out some of the assets out of the trust. We do not put the trust in place, though, anticipating needing to use this. We prefer it isn't used if we don't have to. Then we have the provisions for after death. So during lifetime, the trust is going to protect the assets, assuming we make it through the 5-year period. But even if your parent, your loved one doesn't ever need long-term care, this trust will also serve to distribute assets after they pass away. And in this diagram, you'll see it's cylinders this time, but the same concept is there. We can create those protective trusts for each of the beneficiaries so that we are continuing to build in protection for every layer, every generation of people that we're planning for. And like I said before, when those assets pass to those beneficiaries, those assets will receive an adjusted cost basis. So if the beneficiary then wants to liquidate an asset, their basis in the asset will be the date of death value of their loved one for that asset instead of the basis that their parent may have acquired at the time they acquired the asset. So they're getting a tax benefit with this, the way it's structured here as well. That language does have to be built into the trust. We need to make sure that it's specially crafted language to ensure they're still getting that adjusted cost basis, but our trusts are drafted that way.
So get a Zoomer thing here. So with that fundamental basis of information, we're going to discuss a little bit of our process and the steps upon disability or death that you're going to need to focus upon. Our process is multi-step scenario. The first thing we have with our prospective client is an interview. They interview us, we interview them. We talk about our structure and the kind of things we've been discussing with you folks. And if they decide to proceed, then we move into the design meeting, which could be one, could be multiple meetings, depending on how complex the needs and circumstance are. We then schedule the signing. It's the delivery meeting where we have them review the documents with us and then sign everything. At the end of our delivery meeting, it's on the same time, we do a funding meeting. Megan's emphasized previously, as I have, about the importance of funding the assets properly. There's very little, much less value in having a good trust if the assets aren't transferred to it. So we have a full-time funding coordinator, currently Rich Martino. His job is to make sure that our instructions are carried out to get the trust funded. We then offer a family meeting, either in person or Zoom, to review the trust if clients wish to do that. And then you're sort of on cruise control, our clients, the annual maintenance, of which this webinar is part of that. And then, of course, upon disability or death, we're going to deal with a settlement of the trust. And most of what we're going to talk about is going to deal with that part of the process, the end stage, as it were. So there are various helper roles during disability and upon death. First, we're going to talk about disability planning roles. And I think on one of the handouts, I'm going to share that hopefully here. Here we go. So what you should see on your screen is a handout, very simple, where we talk about the disability planning roles that exist. We talked about the disability panel to determine what if the person, the client, is in fact disabled. If that determination is made, then we're going to make sure that we're going to have an agent under the power of attorney who's already in place, probably the same person as the disability trustee, but not always. Disability trustee is shown on the bottom of the page. So usually the agent under a power of attorney. And why do we have a power of attorney if we have a trust? Well, the most important reason is that with our retirement assets, IRAs, 401ks, and the like, we cannot, under current law, transfer ownership of those into a trust without having that treated as a taxable distribution, which would be a pretty bad mulligan from a tax perspective. But we still want to make sure there is someone readily available in the event of incapacity of the principal to take over and manage those IRAs. And that's where your attorney, in fact, is going to kick in. We also have healthcare agents under a healthcare proxy. This is the person who is designated to make all healthcare related decisions in the event the principal becomes incapacitated. Under D, the one we don't want to deal with is a guardianship. A guardian is a legal fiduciary who would be designated by a court. In our area, in New York State, it would be either through the surrogate court or Supreme Court. This is a court-appointed position. It's a very intrusive and expensive proposition and should only ever be needed if the client has never done, if the person has never done estate planning. If they have a good trust, power of attorney, structure, healthcare proxy, there should never be a need for a guardianship. We're trying to avoid that. So going back to screen 2. We also have the disability co-trustee. We talked about agent under power of attorney. If the client themselves, who is almost always going to be the trustee of their own trust, becomes incapacitated, we need to have a person or persons designated to serve in that capacity. And that's where our disability trustees are going to kick in. And we have a couple of handouts and a few slides that will talk about some of the documents affiliated or associated with the successor trustees.
And then, Rich, if you can, I think it didn't take when you switched back to the.
Oh, okay. There. So it's not on, I have to, okay, you're right. Sorry about that, folks. Is that showing up now?
It is, yeah.
Okay, yeah.
But exactly what you just said.
Good, thank you. And upon someone's death, we have 2 other roles that may kick in at that time. We have the death trustee, who is usually, not always, usually going to be the same person as the successor disability trustee. So again, this is outside of the court system, even though the court would retain jurisdiction over trusteeship. Unless there's a dispute or a problem, we should never be in court when we're transferring authority from me as the trust maker to our successor trustee. The personal representative, commonly referred to as an executor in New York, would only be necessary if we have probatable assets that we need an executor appointed for. In all of our cases, we do our plans, we do include a pour over will, and that is going to say, if I have any probate assets, I will appoint an executor whose job is to retitle those assets in the name of my trust, and then all the trust provisions will carry forth from that. So we like to refer to that pour of will as a legal pooper scooper. It picks up any sort of crap left on the side, maybe a vehicle that we don't put in a trust, a tax refund or a health insurance refund that the client wouldn't have gotten during lifetime. So it's a relatively small process, minor process in the grand scheme of things. Okay. And then we have a process of determining disability. Certainly, if there's a concern that your parent or other loved one may be suffering from diminished capacity, sometimes it's an obvious thing. A person has a massive stroke and is in a coma or something like that, but often and more commonly, it's some graduated diminished capacity. And from what you've learned today, if you didn't know already, we have a mechanism for having the client remove their authority, having their authority taken from them for good reason, because they are making poor judgments or not paying bills or otherwise. And so that's where the disability panel, who is in the document, will kick in. And we're going to worry about getting the certificates of disability enacted at that time. And I'm going to show you some examples of what that would look like. So let me go back to opening these documents. Bear with me a second. We're going to have two of them. One is going to be a certificate of disability that would be signed by the physician. Just remember, in our disability panel, we typically want to have a physician's determination. Third parties are going to be much more likely to honor this panel structure if we have a doctor physician's determination. So let me just open up the other one. Yep. So I'll share the screen over here. So what you should see now in a moment is a basic form of a physician's certificate of disability that is signed by the attending physician that says, I, Dr. Jones, state in my medical opinion and to a reasonable degree of medical certainty that Mrs. Smith is incapacitated or disabled, resulting in her inability to effectively manage her property or financial affairs. It's notarized, and that's one thing. The second one is, let me get that open here. I had it opened. So the non-physician panel member, here it is. So this is similar to that form, but this is going to be signed by, in this example, David Rowe. It says, I've consulted with the attending physician and based on my personal observation and the opinion of my father's physician, I'm of the opinion that David is incapacitated or disabled, resulting in his inability to effectively manage his property or financial affairs. So these are certificates we prepare, identically mirroring the language of disability in the trust instrument, so everyone is on the same page. So I'll go back to sharing the PowerPoint. Is that showing now?
It is, yep.
Good. All right. So Megan, you can pick up going the next one.
Sure. So after the appropriate paperwork is in place, right? Generally during disability or incapacity, we're going to see successor trustees, maybe agent and a power of attorney. There's going to be other people that are starting to do some stuff. And that paperwork is going to reflect that next person's authority to do that. And what that person's going to want to make sure to do is get sort of a good idea of what the financial situation looks like. Now, in our office, we do prepare a spreadsheet for our clients when they first do their planning, and certainly as they update it year to year. We call it the funding verification report, and that's going to be a list of the assets, the financial institutions we know them to exist at, and how we believe they are titled based on our recommendation, or maybe we recommended not to make any changes to it. And so it will have been the same as it existed prior to planning, and that will be reflected on that spreadsheet. So that's going to be something that the successor trustee or the agent under the power of attorney is going to want to be able to refer to, certainly for financial management and taking over that role. If anything needs to be moved, or if maybe, especially in like a trust situation, right? If we have a trust asset and a successor trustee is taking over, the affidavit demonstrating that the successor trustee now has authority should be provided to the financial institutions, so that the financial institutions know this is now the person that we can correspond with, and they have the ability to manage those assets. So here on the screen, you're going to see an example of an affidavit of trust, and this is pretty much what would be prepared if we had an original trustee lose capacity, unable to manage their own trust anymore, and so we have a successor trustee taking over that role. We want to identify some key provisions or features. The name of the trust is going to be something that will appear on this affidavit, the initial trustees, who they were, and how we got to that successor trustee. So in number 3, it says by reason of disability, the original trustee can't serve anymore, and the successor trustees are X, Y, and Z, the following people. Most financial institutions will also need this provision that says the trust is still currently in full force and effect. And then we're going to attach to this affidavit, once it's signed, key provisions out of the trust, so that that successor trustee has a smaller packet that they can provide to financial institutions, carry around with them, and use, as opposed to having to lug around the whole trust instrument. We also do not like to share the full trust instrument with financial institutions if we can avoid it. And so this document helps us to avoid oversharing the trust instrument. And so this would be signed by the successor trustees, assuming they're willing to serve. It gets notarized, and so the whole packet is assembled. Generally, if we've used the disability panel, we're going to have those certifications from each of the panel members included as part of the packet, just to show a third party exactly how we got to where we are. And this should be sufficient for the successor trustee to start taking over that asset management, particularly for those trust instruments. Usually it doesn't require moving things out of a financial institution, but if the institution's being very difficult, we may make that recommendation. So often it's just kind of updating the institution so that you can now take over that role and function. So you're going to see maybe letters of instruction if we do need to make some changes with financial institutions and they're requesting something formal, but often that affidavit of trust is going to be the thing that they're going to look for, and it's going to include all of those pieces, certificates of disability and things of that nature.
Right. And one thing that's often misunderstood is many times we'll have co-trustee scenarios where, you know, 2 siblings will be designated as trustees, but one really is much more active than the other. And even though you're co-trustees doesn't mean they have to always have equal responsibility. So I'm going to go back to one of the handouts here. This is a provision in our trust instruments that basically allows trustees to delegate authority from one of the trustees to another. Essentially, and we have a form of delegation of trusteeship that says, I, John Smith, hereby delegate the following authority to my sister, Mary Smith. And they would check the appropriate boxes, have it signed and notarized, and would reference this section in this example, section 1614 of the trust. And therefore, third parties could rely upon Mary Smith's, if that's the correct name that I just used, authority to act without getting her brother to sign off on anything, because he's already delegated, say, investment decisions or distribution decisions. Doesn't mean you have to delegate between each other, but it gives us the option to make that happen. Going back to our original slide here. What's important to understand, of course, just because someone is a trustee doesn't mean they can do whatever the heck they think they should do. it is imperative that the trustee follow the instructions of the trust. If the trust says only income goes to this beneficiary, you have no authority to give principal, even if you want to. You ultimately have what's known as a fiduciary responsibility. This is the highest legal standard of care that can be imposed in our legal system upon a person. And if you breach your fiduciary responsibility, you can be subject to significant civil sanctions for doing so, fines and penalties if they, or if you're found to have breached that duty. So while it's an honor to be named a trustee or executor, there's also responsibility. And again, as Megan said, you're not forced to carry out that role. If your life circumstance is such that you really can't do it, you're better off declining, and hopefully there's a person named after you to serve. And if not, the court will then appoint someone else to serve if you are unable to do it. But if you have proper legal guidance from a firm like ours or comparable attorneys, then there are plenty of them out there who can do it. You shouldn't have any issue. You're going to be managed properly. Your responsibilities are going to be assisted by the law firm, and you should be in good shape. You have to manage what the property. If there are specific bequests, your job is to make sure those beneficiaries get those bequests. We have some concern, some special issues on, gifting. If during lifetime, if you're a disability trustee, you may be authorized to make gifts to beneficiaries. You should understand what your obligations and responsibilities are in doing so. And of course, if you're stepping into your principal's retirement plan, you have to make sure that the investments are consistent with their needs. And when they reach the required age of distributions that have to come out, you got to make sure that those distributions are paid out, or else the principal is going to be subject to significant financial penalties for not taking the necessary withdrawals. And you always want to work with the best teammates possible, not only you as a fiduciary, but the law firm and accountants and financial advisor. All part of a good team working well together will make sure that the desired outcome is going to be effective for you. Megan, you can take on this one.
Sure. So continuing on with disability and different kinds of roles and functions, we do have a few specific documents that are regarding healthcare decision making. So primarily we've talked about financial decision making for our clients, but what's important as well is the healthcare documents that they put in place and their healthcare decisions and who they've nominated in those roles and their wishes. So like I said, we have a series of documents that pertain to healthcare decision-making specifically. And the one that you see here is our healthcare proxy. And the healthcare proxy is the document where your loved one will have designated, hopefully in an order of succession, a few people who can make healthcare decisions for them when they are unable to make a healthcare decision for themselves. But your job, if you're nominated in this form, is to make a decision that is consistent with your loved one's wishes, if they've ever indicated those wishes to you, or maybe they're written in this document and some of the other ones. You really should try your best to make the decisions consistent with their wishes, even if it's not necessarily what you would have chosen for yourself. If you know their wishes, you do have to abide by it. If you're not sure of their wishes, you should use your best judgment based on what you know of that person and what you believe their wishes are and what's in their best interest. So typically you're going to see an initial agent is designated. Contact information in this document is very important because often it's used in an emergency and we get in touch with people in an emergency by phone. So we want to make sure that that's something our clients are always updating. So if you change your phone number, especially, make sure your loved ones know that, remember that. We have our agents listed in an order of succession because we can't have two agents on at the same time in case they start disputing or debating over some kind of a healthcare decision. And meanwhile, your loved one's laying there waiting for a decision to be made. So you're going to find one at a time, although we hope that the family would work together and make consistent decisions together. Under the anatomical gifts provision, that's the organ donation selection. Now, maybe this is going to be something that surprises you if you ever look at this document. Maybe you're already familiar with what your loved one's wishes are. But there's a lot of different options regarding organ donation. They may have said yes, absolutely. They may have said yes, but only certain parts or not certain parts. They may have said, rather than being strictly an organ donor, I'd really prefer to donate my body for research or for science. Or they may have said, no, I do not want to be an organ donor. And again, that's a very personal choice. Whatever they've indicated on here, you really do need to make sure that's what happens. If they haven't indicated anything, then that is a provision that allows the agent to make a discretion in whether or not that person should be an organ donor if the time comes. And again, if they haven't indicated it in the form, but they said to you, absolutely not, because you know the answer was no, you should stick with no, or vice versa. If the answer was yes, you should say yes. And the doctors will determine if anything is viable regarding that kind of a donation. So the healthcare proxy is a very important document. Often it will list specific wishes or instructions. It will indicate about organ donation. And your job, if you're listed in there, is to follow those wishes. A document that works hand in hand with the healthcare proxy is what's called the living will, and that's what's here. This is sort of that end of life decision-making document. So maybe you don't see this instruction in the proxy itself, but you should always check to see if there's a living will. The living will describes someone's desire to stop all life prolonging care if their health declines to a point where they're in a permanent vegetative state, permanent comatose state, such that the dying process is inevitable. It seems imminent and they're not going to survive this condition. So again, think of like a permanent vegetative state. Doctors have determined there's no chance of recovery. In this document, it has the client, the patient has to meet this criteria in order for it to be effective. But as an agent, you might be prompted by the medical provider to get this document ready in case it comes to that. So you should know where to locate this, or at least to contact our office in an instance where you might need it. In the third paragraph of this document is where you're going to see whether this particular individual wanted one doctor to make the determination they meet this criteria before this document goes into effect, or sometimes they want a second opinion. And so you're going to see that language in here. If they do want a second opinion, it'll say, and at least one other consulting physician must make that determination. So here we want two doctors to agree they've reached this point before the document goes into effect and life prolonging care stops. The fourth paragraph describes what are examples, most common examples of life prolonging care, but this is not an exhaustive list. There might be some other things that you have to make decisions on. Certainly, if you see it listed here, you know this is something they don't want, but otherwise you might have to use your discretion. Is this something that's only serving to prolong their life, not improve the quality of life? It's not going to help them to recover. They may not want that kind of a decision made for them or that procedure. The paragraph at the bottom is one that does generally indicate that pain medication, administration of pain relief, and comfort measures is permitted as long as it's not going to prolong their life. So that's going to be something that you should know you are allowed to authorize. We just want to make sure there's no life prolonging mechanism built into that pain relief, but we want to keep them as comfortable as possible, certainly. So that's the living will. Like I said, it goes hand in hand with the healthcare proxy. That's going to be something that you typically see come up at the end of life. And then I think sort of just the last piece of it would be any kind of instructions that we might find, and we've already talked about this, in the trust instrument itself, especially if there's a revocable living trust. There might be some instructions in there about quality of life and wishes, especially in our older trust instruments. We have a lot of indication there about what kinds of things the client wants to still experience and things that they want to receive, even if they can't make these management decisions for themselves. So this next slide here then transitions us to after a client passes away. So before we're talking about healthcare decisions and disability, now we're talking about after the client passes. Some of the immediate things you would want to do is all of our clients who have done trusts end up going home with a big red binder. It's kind of like a burgundy color red. And in that binder is everything that you should need. So an important thing to do after today, if you don't already know where your loved ones keep their important paperwork, whether it's in a desk drawer, in a filing cabinet, in a lockbox of some kind, hopefully not a safe deposit box, please not a safe deposit box. You should be able to access those documents if you need them, right? So you want to make sure you know where they're located in that person's house. Certainly, you can contact our office to be able to get access to this documentation as well. You're going to want to verify the reason that you're calling us and not the client directly. And then certainly keep in mind that if it's an emergency, which often these things are, they usually will happen after office hours or on weekends. So we may not be immediately available to you. So you should know where the red book is. You should be able to pull it out so that you can access this documentation and kind of see what's what. You're going to want to, in that healthcare proxy document that we looked at, check those organ donation provisions. Even if you think you know what they are, just double check because they can update these documents every year and change their mind. So that's going to be a decision that you need to be able to make right away if that instance arises. In the binder, there's going to be some final wishes and instructions, or if the client filled it out, we do provide them with a lot of worksheets about sort of services and memorial instructions and all of those things. And so if they did work on that document, that's going to be something you want to locate immediately as well as you start the planning process for services, funeral, etc. There's a disposition of remains form for the clients who have updated in the last couple of years. That will indicate cremation wishes, burial wishes, etc. So those are all things you'll want to access right away. You'll want to be able to dig it out of the binder within hours or days of a person passing away because there's going to be those decisions that you do have to make. And like I said, contact the law firm. We're not going to want you to come in right away, right? The day someone passes away, you don't have to be sitting with us in the conference room. But there's going to be arrangements that need to be made, and you may need access to documentation information. And eventually we will set up more of a sit-down meeting with you to go over what the administrative process is. But immediate need would be healthcare decisions, organ donation, and then funeral services, mass services, things like that.
And going through the general laundry list of procedures, we talk about meeting with the law firm. We're going to talk about the various choices the fiduciary has and the time frames are involved. We're going to want to get an updated asset list. We'll have our internal list of what we believe the client owns. It's really up to the family to go through the papers and get that information. Hopefully the parents or the other loved one has been transparent and provides a good record keeping system for their loved ones. You need to make sure, and part of this, again, the counseling on our end is to make sure that creditors are paid. If someone owes taxes or has actual debts that are enforceable, they got to be taken care of, as well as the taxes, as I just said. And let's see the next slide. There may be a special stuff list we have in our portfolios, a personal property memorandum, which it may say my pendant of my beloved dog Milo goes to my daughter Joan, who loved the dog, or whatever. So you want to make sure that if there's a special stuff list, you've gone through that. We're going to talk about how to transfer assets into the ongoing trust and establishing tax ID numbers, and what the beneficiary gets out of this. We do a letter to each of the beneficiaries explaining why they're getting assets in a trust and how it works and why it's to their benefit to have that. Before we go there, I do want to, before we get to any follow-up questions, I'll share on the screen. We talked about a disability certificate for an affidavit of trust upon disability. Here we have one that is upon death. So here it's an affidavit of successor trustee that would then be provided. Unlike the other one, the disability certificate, where we use the client's social security number because they're still living, here there would be a taxpayer ID number obtained. We would typically do that from the IRS website, and we would then list the trustee names, and that it was number 7 on the list shows that the trust maker died on, this example, January 10th, 2012, hence the need for successor trustees because the original trustee is deceased. and we talk about delegation information. So this is a standard form, also notarized. Third parties are going to get this, along with, as Megan said, selected pages from the trust that show the validity without oversharing, using her terminology. And this, again, will provide legal evidence that now Mary can no longer be trustee. She's deceased. Here's her death certificate. But these people identified in the trust now have full authority, a seamless transition from living person to the successors without court intervention can be done in a matter of minutes, not months or years. Huge, huge benefit to our family. So that covers, hopefully in a reasonably succinct but informative manner, excuse me, the general process we use, the trust administration process. If people have questions, you should be able to answer them or raise them in the chat or Q&A box. I haven't seen any come through today. We've either dazzled you with our information or bored you to tears or some combination of those things. This is being recorded, as I mentioned earlier, so you can go on our website in a week or so and view this to your heart's content. And we do, we would accept, of course, emails, follow-ups for you, from you, either to Megan or myself, if you have additional questions. But other than that, we're gonna adjourn the webinar for now and wish you a good spring. Thanks for participating, and we're here for you and your family to really make any process that we're involved with your loved one as seamless and transparent and easy as possible. Any parting words, Megan?
No, just thanks everyone for attending. And like Rich said, we're here if you need us.
Thank you again. And again, we do this a couple times a year. If you want to hear it again live rather than just recorded, feel free to join us at a subsequent time. Again, thanks for joining us, and we are signing off. Have a good evening.